SI.com legal analyst Michael McCann has been our guide to the legal ramifications of the lockout each step of the way, and Michael is with us once again. Mike, there's been a growing movement within the players' union to decertify. The players chose instead to disclaim the union. Could you explain to viewers what is the difference?
Sure, Matt. So they're very similar, but the benefit of disclaimer of interest is that it can be done more readily as opposed to decertification, which takes 45 to 60 days. So now, by disclaiming interest, the players can file an antitrust lawsuit that they wouldn't have been able to file for almost 2 months. So they can go to court immediately. The downside to disclaimer of interest is that the league can now argue that the players are merely breaking up their union so that they can use antitrust litigation, that they really aren't bargaining in good faith, that they're trying to bully the owners through antitrust law. And of course, the NFL players tried this tactic and it didn't work for them. So the NBA may believe that they will also prevail on any kind of litigation.
Michael, if we do proceed with an antitrust lawsuit, which we all expect in the next day or two, can you walk us through the timeline? How long do antitrust lawsuits take if they really work out to their full time limit?
Sure, Stan. So in many cases, antitrust litigation takes several years. And I know that sounds dire given that we want to have a season. But typically, complex antitrust litigation is not something that's resolved in a period of weeks or months. It's resolved in a period of years. And that doesn't even include appeals. So it's in all likelihood, in a case of this complexity involving a whole bevy of issues, including the legality of the lockout, including the legality of things like the salary cap and the draft, they would all have to be argued with lots of evidence and expert witnesses. If this ever were to go to trial, this is not going to be immediate. This is something that would take years if, in fact, it went to trial and a jury heard the case.
Well, Michael, sticking with that point, do the players' contracts become void? Front office, people who work for organizations, how do their deals work from there?
Sure, 3D. So the league has argued that if the players decertify, then the uniform player contract can be voided for all players because it's located in the collective bargaining agreement, and the players would be signaling that they no longer want to negotiate. Now, that's a novel argument, and I don't think it's one that's likely going to happen. I don't think we're going to see player contracts voided. I don't think we're going to see the league take that approach, at least not for a while. I think that would be a pretty bold move on the part of the league. In terms of employment contracts between coaches, other employees of teams, and the team itself, those are not going to be, in all likelihood, impacted by the CBA. Those are just employment contracts that have to be negotiated between the individual employee who's not part of a union and his team.
Michael, let's talk venue here. Obviously, there's different venues that may be more friendly to the players' union than others. You hear that New York is friendly in certain areas, and California and Illinois might be friendly. Where might we see the players filing this lawsuit?
So, David, I think we could see the players file the lawsuit out in California or anywhere in the U.S. Court of Appeals for the Ninth Circuit, which is out west, where the courts there are generally seen to be more pro-labor, pro-union, and their case law would suggest that the players have a better chance. In addition, the U.S. Court of Appeals for the Eighth Circuit has some favorable case law as well. That's also more or less out west. The league, however, is going to argue, well, it doesn't make sense to have a case out in California. We've already filed a lawsuit in New York. Not only that, right, but the league and the Players Association, or I guess now we should say that the trade association, formerly known as the Players Association, is headquartered in New York, and it wouldn't make sense to have a case out there that the best venue would be New York. But in New York, the case law would favor the league.
Michael, is there anything that would keep the NBA from opening its doors, saying, hey, we'll see you lawyers in court, but we want to start the season, so we're going to start the season now, and anybody that wants to come and play for us, we'll sign them to individual contracts, even if there's no Players Association to negotiate on their behalf. Is that even legal?
See, David, I think it would be an interesting idea, but then the league would set itself up for antitrust litigation in another way, because any kind of rule that's negotiated among competing teams would be subject to federal antitrust law unless it's been negotiated through collective bargaining. That the benefit of collective bargaining is that it insulates rules that the league likes, like the salary cap, the draft, from antitrust scrutiny. If the league were to open its doors tomorrow and say, we'll do individual contracts, but we're going to have a salary cap of $60 million, and we're going to have a 3-round draft, they would be subject to antitrust law and a whole separate slew of lawsuits.
All right, Michael, I know this. We may not have an answer to this until it all plays out, but tactically, strategically, how wise a move was this by the Players Association, Trade Association, excuse me?
Matt, I think the move should have been made earlier if they were going to pursue this path, to be honest. That by now, the timetable is set up that the league is poised to cancel the season. And I don't see how that's a victory for the players in any way, shape, or form. That the likelihood of this case ever going to trial and then hearing appeals and taking 2 to 3 years is never going to happen. And if that happens, how old are players going to be? If a player loses 2 to 3 years of his career, that's like most of us losing, 15, 25 years of our careers, given that they can play for such a short period of time of their lives. I don't see that in that regard the move was good. On the other hand, the Players Association can say one thing that the NFL Players Association couldn't say. And specifically, it's that the NFL Players Association disclaimed interest right after the lockout. And the courts out in the Eighth Circuit said, well, why didn't you wait long? Here, the Players Association can say, we did wait longer, but ultimately it didn't work out.